Good afternoon, everybody. My name is Chris Justice, and I'm here on behalf of Samfiru Tumarkin. As always, I'm an employment lawyer working with Samfiru, and I'm here as always to answer as many questions as I can today within the time allotted, all things to do with employment law. Maybe you're going through some issues in your workplace. Maybe you've got a boss who's hounding you about something. Maybe the workplace has become toxic, and you're wondering sort of what your options are. Perhaps you've lost your job, and you're wondering whether the severance package you got was fair and reasonable, or maybe you're just entering a new job and you've got some questions around a contract they may want to have you sign or something of the like. So as I say, get your questions in, and I'll do my best to answer as always. There have been some topics going around in the news, some things that is fairly common, at least from what I've talked about in more recent episodes. One of which has to do with more companies letting people go, ranging jobs from vice president positions to laborer roles, but there are very much ongoing layoffs continuing in various different industries. So if you're somebody, for instance, who has lost their job because of some restructuring that may have happened in the workplace, maybe you've been told that you're not the right fit, or they had to do some cost-cutting measures and therefore lay off you and maybe others, and they've given you a package, you definitely want to give us a call before signing off on anything. You don't want to sign a release or anything thinking you might be getting a huge sum of money that looks fair, and then after the fact realize that what they gave you on your way out was only a fraction of what you could be entitled to. As many of you out there know, in terms of severance, in terms of the potential severance you could be owed in this country, in this province, people can get upwards of 2 years of severance. It very much, though, depends on things like how old you were at the time you were let go, what kind of position you had. For instance, I mentioned anywhere from a vice president or president of a company to a laborer. Typically, the more senior the role, the more severance is going to be owed. That also has to do with the amount of money you might be making in your role as well. And also how long you've been at the company. That's going to be another one of the main factors that sort of determines how much severance you're entitled to. But as I say, the potential is there for upwards of 2 years worth. So at the very least, give us a shout if you have any questions or any possible doubt as to what you're being offered, or in any case, because most of the packages I see in my line of work, probably 80 to 90% of them are packages that are well below what you're generally entitled to. So that's number one I wanted to just raise off the top. There's other stuff going on in the news. Again, this was something I touched on a previous episode, but with the temperatures going up, with summer now here, there are a lot of workplaces that have temperature-related issues. There's situations where maybe the working environment is not safe because the temperature has risen so much. Maybe you're in a factory or an office or just a workspace that may not have air conditioning, and so the temperatures can get quite elevated at this point in time. And if you're in a position like that, especially if you think that based on the type of work you're doing, maybe based on how long your days are, you have some serious concerns about being able to do your job in an environment where the temperature is relatively high. There's no set number of degrees or threshold in terms of how hot it needs to be, as far as what the law would say on the issue, but employers do still have a duty to accommodate. They have a duty to ensure that the workplace you're in is safe, is healthy, and sort of included in that are issues relating to temperature. So if you're someone who may have a medical condition that would sort of have you not be able to work in certain conditions, or maybe you're just someone who's asking for some more frequent breaks, to get a glass of water, whatever the case may be, these, I think, are reasonable requests for you to make, especially if there are those serious concerns. So it could be more frequent water breaks. It could be not working maybe outside during certain points of the day, or reducing the length of a shift. It goes back to there being maybe more frequent breaks. those are just some measures that you could suggest to try to accommodate the situation so that you're not overheating, you're not getting into any sort of danger situation as far as that's concerned, but you're still able to do your job or most of your job. And as long as that's the case, the company, your employer, generally has to accommodate those issues. If the employer, however, insists that no matter what, you're going to be working a certain number of hours, and maybe the employer isn't sympathetic towards your concerns about temperature levels rising, even after you've come to them with concerns, maybe come to them with some proposals on how to stay cool, in this heat, then that's where employers tend to get into a bit of hot water. And that's where they could risk a court finding that there's a constructive dismissal, that there's been this breach of the safe requirements in terms of the workplace, that there's been a breach of their duty to accommodate and to ensure that these issues don't lead to any concerns, especially health-related concerns. So if you're in a situation like that as well, you've already tried seeing if they can accommodate, maybe some negotiation took place and they just don't want to hear anything of it, then definitely give us a call. Because as I say, while there may not be a set number of degrees that you're legally able to work in, it is very much a case-by-case basis, depending on the nature of your work. And so I thought that would be a sort of a more topical thing to bring up now that, as I say, we're kind of entering the summer months, and I'm sure the temperatures are going to continue to rise. With that said, I'll get into some other topics I had off the top. I'm just going to go to one question, though, from Marlene, who is saying, if a company lays you off for a mental health, maybe a mental health leave, are they obligated to rehire you when you're cleared by a physician to go back to work? So and I just want to be clear, if you're an employee who requests a medical leave of absence or a health-related leave of absence because of some condition, whether it be physical, psychological, emotional, and the company essentially has you go on the layoff, you take this, I say layoff, you take this mental health leave, then yes, generally when you're able to come back, especially when you have the clearance from your doctor, the employer is supposed to keep the position you had or something very similar to what you had available for you upon your return. So that doesn't mean that they can just simply wait, a few weeks or a few months and then give your job away. Your absence may extend beyond a few months, but that's what a company has to do, is keep that position available for you on your return, unless there's some evidence that's saying, you've been off for several years and there's just no hope that you're ever going to come back. Then there may come a point in time where ties need to be severed, but otherwise, no, they do have to obligate you. Now, Marlene, because your question mentions a company laying you off for mental health reasons, there could be a bit of an alarm bell rung there. I just wasn't sure if you meant that you went on a mental health leave and they were okay with it, or if the company put you on some sort of a layoff for mental health reasons. Because sometimes if a company is the one that takes the action to put you on a layoff, or maybe a company says, we're putting you on a mental health leave, sometimes that's actually against your own interests. That may not be necessarily what you're asking for. A lot of times companies lay people off without their consent. That can be particularly problematic if there's no agreement to being laid off, or if you haven't signed anything that says they have the right to lay you off. So that could be a separate sort of side issue as far as whether they had the right to do that and whether that constitutes a termination. But if there was a general understanding, a mutual understanding that you would be off for a certain period of time, maybe an indefinite period of time, with the idea that you're going to be coming back, then yes, they're obligated to keep that job available. If they let you go, if they effectively terminate your employment for mental health reasons, that's again where employers can get into hot water. Once you're sort of terminated, which is different than a temporary layoff, there is no general obligation for a company to rehire you, say, for instance, sort of starting fresh or as a new employee again. So it just depends on the language there. As far as by layoff, do you mean you're indefinitely laid off? In other words, a termination, and there was no understanding that you'd be coming back? Or was it, I'm going on a temporary leave or a layoff with the understanding on both sides that I would be returning? But if they terminate someone or lay somebody off permanently for mental health reasons, then that could definitely be a human rights violation. Even if it seems to make sense to them, you can't terminate someone for reasons relating to a disability, mental health condition, or a number of other grounds under human rights legislation. So depending on sort of what the situation is there could be a bigger issue than not. But for those out there, if you're on a leave of absence for medical reasons, you should expect your job is going to remain intact if you're able to come back. I've got another question in from Snipple, who's asking whether or not their company is allowed to require a written doctor's note for sick days and reject a virtual note. So it would depend on, number one, how long the absence is for. Generally, if we're only talking a day or two or three, there's not going to be necessarily a requirement for a doctor's note. When it extends beyond that, or maybe there's a number of absences that have happened over a short period of time, generally companies are entitled to ask for some written note, some sort of verification or support from the doctor. Now, this note doesn't have to be incredibly lengthy. I know a lot of times companies want to get as much medical information out of their employees as they can, and that's where they overstep their bounds. But I've seen in many cases a note being prepared that'll say something along the lines of, so-and-so is a patient of mine. Maybe I met with this person in person and did an examination, or nowadays these things do happen virtually more and more. So there could also be a sort of like a virtual meeting or a virtual examination, depending on what the nature of the illness is. And I would say that in general, that also should suffice. So in some respect, it comes down to the case, but there are definitely instances where you can get a note and you can get that done through a virtual meeting as opposed to an in-person meeting. There's not sort of a bright line rule that says you need to have a meeting in person with your physician in order for us to accept a note. And again, this may be a situation where the employer may want a certain note or a certain note to say something in particular, but just because they don't get what they want doesn't mean that that's not a sufficient note to provide as a basis for someone's absences. I definitely think getting doctor's note, whether it's in person or virtual, is always recommended, because then obviously you've got your word, you've got your doctor's word, and it's going to be much harder for the company to sort of take action against you or somehow find what you did insufficient. And if they do refuse the note, or they insist on you doing something or being somewhere where your doctor's already given you clearance that you can't do it or shouldn't be there, then again, that's where employers are going to get into hot water, and they're going to be more likely seen as failing to accommodate an absence or failing to do what they need to do as far as that duty of accommodation more generally is concerned. And a lot of times employers just won't accept it. They'll say, this isn't good enough. We want something better. If you don't give us something better, we're going to let you go. We're going to lay you off. And they sort of take all these other retaliatory actions. And again, that's where they can get into a lot of hot water and sort of open a can of worms in terms of not only just paying you severance potentially, but now human rights damages, punitive damages. So it can definitely have a domino effect for the company. But Snipple, I would say give us a shout as well, just so maybe we have a better understanding of the situation, what your medical condition is, maybe what communication or correspondence you've passed between yourself and the company, maybe what notes have been provided, or maybe the doctor themselves is trying to think about what needs to be required in the note. So there are a lot of overlapping issues here, and we would just want to make sure that before you get too deep into it, maybe before more serious actions are taken, you kind of paper your trail and make sure you're setting yourself up for as much success as possible, so that if, worst case, the company does do something inappropriate, you've already papered the trail and you're basically giving them much less of a leg to stand on if they do decide to make a more rash decision. But thanks, Snipple, for the question. I've got another one in from Hybrid who's saying or asking whether a company can say there are jobs available while not giving specifics as to what jobs actually exist to avoid paying severance. The company is eliminating our department and have tried saying that we've declined other roles, but they have no current roles. Our temporary layoff has been extended. What are my options here? So seems like the company is saying that they've eliminated the department, and as a result of that department being eliminated, in some way your roles have also been eliminated or affected. And it seems like they're saying there isn't the role that you had currently available, and hence the reason for them to put you on this so-called temporary layoff. So first of all, anytime a company puts you on a temporary layoff, they have to have your consent, as I was mentioning a little bit earlier. They need to have your consent at the time or just before putting you on the layoff, usually by way of a letter that maybe is signed by yourself saying you agree to be placed on a layoff, or they need to have a document, a contract maybe in the past that you would have signed that allows them to put you on a layoff. Because if they do have your consent, whether it's, say, verbally or in writing in some way, and it is legitimately the case that they've eliminated maybe your role or other roles, then they may have the right to put you on a temporary layoff for a certain period of time. Now, that period doesn't go on forever. Just like in the case of someone on a medical leave of absence, once you come back, you're expected to be given the role that you had or something very similar. So, as for an extreme example, if I'm a lawyer and my firm comes to me and says, we're eliminating the lawyer roles, all we've got available now are, legal assistant roles or secretary roles. And now I'm having to figure out, well, I'm on this layoff, say it's legitimate, I'm coming back, but now I'm coming back to a secretary or assistant role. That's not like the role I had. That's not even similar to the role I had. And a company can't then force you or put you in a situation where they say, either you come back to this new role that we're offering you, or you quit your job. Because if the evidence shows that whatever this new role is, if it's not comparable, and you're, let's say, on a legitimate layoff, and that time is now come and gone, and they can't put you on a layoff any longer, the only direction usually is you to go back to work. But if you're not going back to a role that you had or something comparable, then you're effectively agreeing to go back to something that's significantly different. That would be a breach of the terms of your own employment. You typically would sign a contract or agree to work for a company with respect to a specific role. So if that role has legitimately been removed, okay, that may be one thing. That may provide a basis for why the role no longer exists. But the company still has to find something comparable or identical to what you had upon your return. And if they don't, then the law is going to say that automatically is a termination for which you're going to be owed your severance. Now, I say all this assuming that the layoff is legitimate. If they just put you on a layoff and you never consented to it, you never sign any agreement or contract that says they have the right to do that, then just the fact of them putting you on the layoff alone is going to likely mean there's been a constructive dismissal. And so whatever the day is that they put you on a layoff, you could claim that as your so-called termination date, and then potentially go after the company for severance. So that's one thing. If they don't have the right to lay you off, you could be in a position where you're owed severance right now. If they do have some sort of evidence suggesting you consented to the layoff, then it looks like you're probably going to be owed severance in any case, because there either isn't any other job available, or the ones that are going to be very much different. So give us a call. Hybrid definitely seems like we can be of help and try to get you what you're looking for, or at least give you a sense of what all your options are. I've got another question in from No Temperature, who's saying they've been on a maternity leave for a year. They notified HR and their manager that they would like to extend it for another month. And after telling them this, they were told their benefits would not continue past the original date, which I assume to mean the original date of the return from the maternity leave. So I guess you're just asking for another month, and they're saying that they won't continue your benefits for that month. Is that allowed? I mean, that could arguably be a breach of the terms of your employment. It could be implied terms. It may not necessarily be something that's written down, or it could also be a breach of some explicit or specific term of your employment, say something in writing. So there could, on the face of it, be a technical breach. I guess the question would be, though, is the removal of benefits for 1 month, assuming you only need another month past the original return date, is the removal of benefits for that month sort of enough that would trigger any substantial right that you would have? Probably not. Usually when a company breaches a term of someone's employment, could relate to benefits, could relate to pay. The question is whether the breach is a significant one. So, for instance, if I make $50,000 a year and my company comes to me at the end of the year and says, next year, Chris, you're only going to be making 49, even if I don't agree to it, it's $1,000 less a year. A court may not view that as significant enough of a change that would give me any leg to stand on. And so I might be in a position where I just simply have to accept that change, or perhaps leave the company and go seek greener pastures. So it also, no temperature may come down to further specifics in your case. I always say, give us a shout. Maybe we can flesh through the case, the facts in a bit more detail. It seems a bit silly, I suppose, to sort of have the employer push back on just an extra month's worth of benefits, but maybe there's something more to it, and you may have some more options. So give us a shout for sure. And at the very least, we can set up a consultation to kind of go through your case. And as I say, just give you a list of what all available options you have would be. Break It Like is asking whether an employer can make a retroactive change to a temporary layoff and claim it was a termination instead. That's somewhat of an unusual circumstance. So they lay you off initially, presumably because of some economic related reason, or maybe your job was eliminated or whatever, something happened. They place you on a layoff. Again, question for me would be, do they have the right to do that? So you're now on this layoff, and now they're claiming it was a termination. Well, usually if an employer doesn't call you back from a layoff, at a certain point in time, it's going to automatically turn into a termination. Another example would be if you're put on a layoff, let's say, and 2 months into your layoff, the employer says, you know what, we're just going to let you go. We're going to fire you. An employer could do that too, depending on whether the layoff initially was even legal. And at that point, that would signal the end of the relationship. They would have to give you severance. It's a bit more unusual, your sort of situation. So they're saying they put you on a layoff, and then they're saying, well, we're just going to make your termination of employment effective the day we put you on a layoff. Yeah, I'd have to investigate that a bit more to understand what exactly they mean, or if they just mean that they've decided at this point to turn this layoff now into a permanent termination, which, again, if they were to do that, you're likely looking at your full severance. So you'd want to definitely give us a call to make sure, if they do terminate you, what are they offering you? Have you signed a contract that possibly limits your termination rights, your entitlements to severance? It's very rare, but there is the odd case where maybe something you've signed in the past could affect what your rights are now after the termination. I'd also want to know what the reason for the termination was, maybe what the reason for the layoff was. Sometimes there are ulterior motives, there's bad faith, and that can be used as well for extra leverage in a case like yours. So, but it does seem like you're being terminated and you're looking at some severance at the very least. So I'd give us a call. We can talk it through as well with you, and just make sure you're in the best position you can be in. I've got another question in from Gassel, who's saying that for over a year now, their employer has been deducting hours from their check without telling them, or making quote unquote mistakes on payroll that ends up being that the hours aren't paid out or counted, saying that this happens almost every paycheck. They do make the corrections and add it to the next pay, but only if I catch them. And I'd be thousands of dollars basically out of pocket at this point if I hadn't started my own tracking. Is there anything legal I can do to force them to stop this? Well, I mean, look, I'd be taking a good account of the hours you work. I'd be maintaining as best records as I can. And almost before the payout even happens, I would be sending them a note to some effect to say, look, I've worked these hours, given in the past there's been some issues. I just want to make sure, so that you're not having to go back after the fact and try to track down everything. I mean, there does also come a point in time where enough's gone on where you could suggest there's definite bad faith. But I think the question is, Like, what are these mistakes on the payroll that's causing them issues? Are these mistakes that should have been corrected long ago? Just curious to find out what sort of defense, I guess, for lack of a better word, the company has, and also why it is, if it's not a mistake, why they're deducting hours off your paycheck. It could be a situation where their systems are just disorganized and they're just a mess in terms of from the company side of things. But obviously, that's a huge problem. You want to make sure that you're getting paid for the hours you work. So I guess also depending on how fluctuating your hours are from week to week, I don't know how difficult it would be to track it, but I'd definitely be tracking it. And if I had the evidence over a number of weeks after tracking myself of them just continually screwing things up, I do think it gets to a point where it's the straw that broke the camel's back. You're expecting to get paid on time. You're expecting to get paid an accurate amount. So if the company is continually breaching these things, there's only so many mistakes that can be made, right, before they need to fix that situation. So you also may be in a situation where you don't need to track. You may have an opportunity to leave at this point, given the multiple instances of breaches, and sort of treat this conduct as though it is a termination, and then go after the company for your full severance too. That may not be what you want. Obviously, it would mean potentially the loss of your job and having to go find another, but it could be at least another option for you. So I'd say give us a shout. Be good to know sort of, again, what these mistakes are, how long this has been going on, how much money you've lost, and again, what their basis is for what's going on their end. But yeah, you definitely don't want to be out of pocket thousands of dollars, and who knows at this point. So you definitely want to make sure going forward, there's no risk of that whatsoever if you're not going to leave, if you don't have a leg to stand on there. But give us a call in any case, and we'll do everything we can to help out. I've got just a follow-up from Break It. Break It earlier had sent in an email or a question about a retroactive change, sort of what was once a layoff is now a termination. Break It is saying that they were laid off because business was slowing. We had fewer clients. So that seems to align with a lot of rationale I hear from companies about layoffs. They mentioned a few mistakes being made before being laid off, but now they're being brought up. I mean, I guess there could be a scenario where someone's laid off, let's say for legitimate reasons. During the layoff, the company discovers some errors that were made that, reasonably speaking, they wouldn't have known about before the layoff. Sometimes that does happen. Or even there are situations where someone gets terminated without cause. They get offered a severance package, but then after they're terminated, the company comes back and says, actually, we found a bunch of dirt on you. We didn't know this was going on, but we just discovered you stole this or stole that. We already fired you without cause, and we offered severance, but now that we found out this stuff, we're now switching our tune, and now we're going to let you go for cause. So it's not quite like your situation, Break It but there are scenarios where a company takes a certain action and then after the fact discovers something that, again, they shouldn't really have the opportunity to know about before, and then they change their stance. So I guess another question, though, for me, Break It is if they've let you go, assuming it's without cause and assuming they're offering you some kind of severance, there's probably not a ton you can do to stop that. Generally, companies are entitled to let people go at any point in time, unless it's for discriminatory reasons or someone's on a maternity leave or whatnot. But the key question then just becomes, how much are they paying you? How much severance are you getting? Now, if they're alleging that you made these mistakes and that it's serious, and now they're letting you go and not giving you a dime on your way out, that's where it can be more problematic for them, and where they a lot of employers, I think, jump the gun and pull the trigger too quickly. So that would be a much larger red flag for me. But I'd say give us a shout. As I said before, we can take a look at whatever it is they're offering you, or what the basis is for letting you go, or what these mistakes were. But to me, it seems like you're probably looking at some money here. So let's just make sure that you get every cent you can. With that said, though, that's my time for the day. I do appreciate everyone, as always, for bringing in their questions. For those of you that I didn't get to, we have this stuff going on all the time, just right there below. This Wednesday, you've got Mr. Samfiru showing up. So tune in 1 o'clock Eastern on that day, and he'll answer as he always does. But for me, that's my time. So thanks again. Hopefully everyone enjoyed today's session, and have a great rest of your day. Thanks. Take care. Bye for now.